the parts of her matter, my lord.
It will be taken prior to recess, not now.
This is order ought to hand
Parted.
order.
Alright, এটা রেখে দিন। I'll take it up
Yes, my lord.
prior to recess. Give the order, এখানে রেখে দিন। Yes.
My lord, last occasion matter was taken up, and my lord, my lord, kindly turn the order passed by the board, page number 34. The case is that, my lord, in nutshell, a criminal complaint lodged against the petitioner, and she is a teacher in the year 2022. Thereafter, my lord, she was suspended. She was in custody. She was suspended. Till date, she is under suspension. It's a prolonged suspension. My lord is well aware of the fact.
What happened to the criminal case?
Still pending.
And what are the charges?
Allegation of selling out of 8 Shobut Shadi cycle
And my lord, that
to
too,
some other person, which was confiscated by the police, and some other charges also.
Has any disciplinary proceeding been initiated by the school?
that will be intimated by the board. Kindly turn page number 34. That's the reason, my lord.
No, page 34 I can see.
Yes, but no, that's my humble understanding as well as the instruction is that no such DP is initiated by the
School
authority. No, my lord, that is
Board also did
board.
not initiate.
But this is not a power of the school authority. That is the power of the board. Specifically, 2018 rules is.
See, the board has mentioned that
Yes.
our presence will be detrimental to the
Yes,
institution.
my lord, that's the reason, my lord. They ought to, my lord, initiate the departmental proceedings and in the,
Not necessary.
my lord, kindly see the rules, 2018 rules.
Is this the stand of the board still now?
Difficulty, my lord, because she was a TIC of the school when this thing happened. She was suspended from release from
What is the
custody.
stand now?
Yes, my lord. What happened, my lord? As because it is because of this Shobut Shadi thing. So, my lord, board has asked the DM to hold an inquiry and submit a report to the board, on basis of which show cause will be issued and other things will be done. But, my lord, we have written 2 times to the DM, once in August 2023, and the second in April 2024. But, my lord, we have not received any inquiry.
What is your stand now?
And our stand is, your lordship, there is an allegation of this, my lord. Once your lordship may kindly direct the DM to file a report to us, holding an inquiry within a limited period of time, and board to conclude the disciplinary proceeding.
See, the disciplinary proceeding has not started.
Not yet.
And you have not approached the court against the DI or anything of that sort. The DM. Now, the teacher is over here. She prays for rejoining.
Yes.
Well, she is getting a subsistence allowance without doing any work.
Yes.
Now, if you do not give her that position, previously she was a teacher in charge.
Now she is not.
She is not.
No.
If she joins as an assistant teacher, then she will not have that power to do all these things. You can utilize her services, and he also gets her pay and everything. And whatever is done, and whatever will be the fate, will be the fate. But then, unnecessarily keeping her outside the school, the students are not getting her services. She is getting her pay, enjoying at home. Think it over, what is to be done. If you want to obtain further instruction, you take.
Lordship, as per rules, your lordship, what my learned friend is showing, my lord, I can't go the other way. Because from suspension, there is a time period fixed where we have to proceed with the disciplinary proceeding. But charge sheet not initiated, so my lord, I cannot say proceeding has been done. But my lord, as because the allegation is a very grave in nature, so my lord, only my submission would be, my lord, a direct.
Well, kindly
my lord, even if a lordship allows, my lord, even if a lordship allows her to join, then
how
also
who am I to allow her? You will take a call.
And the statutory provision is very clear. Kindly see the rule 6.3. Just one.
Nobody to direct her to join.
But statute says so. Kindly see text 6.3, rule 6.3. But statute says so. Suspension. The 6.3. Kindly take 6.3. Rule 6, sub rule 3. I just place the suspension provision.
Yes.
If the disciplinary proceeding is not initiated or contemplated within the 90 days from the date of receipt of the investigation report, or if the teaching or non-teaching employees has been released on bail, the concerned teaching or non-teaching employee may be allowed to resume his duties subject to the condition that such joining of the teacher or non-teaching staff will not hamper the normal running of the institution.
Well,
So
it-
very
yeah, but-
clear.
yeah, but
And the in
it is clear, your lordship,
and
within
in
90
absence
days
of that,
from
Supreme
receiving
Court
of the,
judgment is very clear, categorical, that within 90 days, if you not initiated any DP, then ought to.
my lord, within 90 days from the date of receipt of the inquiry report, that inquiry report is still awaited, my lord.
Let's see.
Yes.
Well, it is not 90-day from the date of suspension. It is
Para
it
21.
was from the date of receipt of the inquiry report.
Why
That
not
we have
be-
not received.
Then I place the 6, 1 and 2,
Paragraph
21.
21.
And subsequently, by relying this, 2018 is there. I can
কি দিবি বল না, আমার judgment
2015 7 SCC 291.
কত কত?
2015 7 SCC 291. Prolonging suspension is not permissible.
2015 7 SCC 21 আর একটা আছে কি?
ওটাকে কনসিডার করে
The
grateful, my lord.
petitioner was serving as an assistant teacher in a school. Stop. On detection of certain illegalities against her, she was taken in custody and released on bail on 8th February 2022. Stop. The petitioner was put under suspension by the school. Stop. After her release, she sought for joining the school. Stop. By a communication of the West Bengal Board of Secondary Education, dated 14 September 2022, the board opined that the presence of the petitioner to resume her duty in the school will be detrimental for the institution. Stop. The board has not reviewed its position till date. Stop. The petitioner is still under suspension and receiving a suspension allowance, subsistence allowance. ঠিক আছে? Prayer has been made. না তার আগে it has been submitted that disciplinary proceeding in terms of the WBSE within bracket appointment confirmation. এটা দেখে নেবেন, হ্যাঁ, bracket close rules, 2018, no disciplinary proceeding has yet been initiated against the petitioner. Prayer has been made to permit the petitioner to rejoin the school. Paragraph. Submission of the petitioner is opposed by the learned advocate representing the board. Stop. It has been submitted that on the date of the incident, the petitioner was serving as the teacher in charge of the school. Stop. Allegation against her is in relation to disposing of bicycles meant for the Shobuj Shathi scheme. Stop. The board requested the district magistrate to conduct an inquiry and furnish a report Stop. Despite reminders given to the district magistrate, comma, no inquiry report has been forwarded by the DM to the board till date. Stop. For want of proper inquiry report, not proper, for want of an inquiry report from the district magistrate, comma, the board is not in a position to initiate disciplinary proceeding against the petitioner. Step. It has been submitted that necessary direction may be passed upon the district magistrate to conduct the inquiry and forward the report to the board for initiating disciplinary proceeding in the matter. Paragraph. Rule 6 of the aforesaid rules has been placed before the court. Stop. The same relates to suspension. Stop. 6 within bracket 3 of the aforesaid rules mentions that if the disciplinary proceeding no 6(2) likhun
2 and 3.
2 mentions that in all cases of suspension, comma, a disciplinary proceeding has to be drawn and concluded as required under rules. Paragraph 6(3) mentions that if the disciplinary proceeding is not initiated or contemplated within 90 days from the date of receipt of investigation report, or if the teacher or the non-teaching employee has been released on bail, comma, the concerned employee may be allowed to resume his duty, subject to the condition that such joining will not hamper the normal running of the institution. Stop paragraph. In the instant case, it appears that disciplinary proceeding has not yet been drawn against the petitioner. Stop. She has already been released on bail. Stop. On the date of the incident, the petitioner was serving as the teacher in charge and she had the scope to take decision in the matters relating to the beneficial schemes floated by the government. Stop. As the petitioner is no longer serving as the teacher in charge, comma, she will not be in a position to utilize her status of assistant teacher to take any advantage. She will not be liklam na. She may not be in a position. To take any, she may not be in a position to interfere with the day-to-day functioning and the affairs of the school. Stop. She is receiving her subsistence allowance without performing any work. Stop. Nearly 3 years have passed. not nearly, more than 3 years have elapsed from the date of her release on bail. Stuff. As the board was of the opinion that her resumption in school may be detrimental for the institution, accordingly, the court thinks it fit to direct the board to review the issue all over again. Stuff. If the board is still of the considered opinion that the presence of the petitioner will hamper the normal running of the institution, comma, then the same may be formally communicated to her. Stop. If the board finds that her presence will not interfere with the normal functioning of the institution and the same will not be detrimental to the school and the students, comma, then the board may review the suspension of the petitioner and and permit her to join the school. Stop. A decision shall be taken by the board at the earliest, but positively within a period of 60 days from the date of communication of this order. Stop. Writ petition stands disposed.
Read fully, Lordship.
Headphone.
আইনের নামটা একটু লিখে নেবেন।